This is Bloomberg Law with June Grasso from Bloomberg Radio.
As part of my plan to secure the border on day one of my new term in office, I will sign an executive order making clear to federal agencies that under the correct interpretation of the law, going forward, the future children of illegal aliens will not receive automatic U.S. citizenship.
President-elect Donald Trump has promised to end birthright citizenship as soon as he gets into office. The policy means that anyone born in the United States automatically becomes an American citizen, even if they're born to someone who's here illegally. The leading Supreme Court case on birthright citizenship dates back to 1898, and any attempt to get rid of it will certainly face legal challenges. Joining me is immigration law expert Leon Fresco, a partner at Holland Knight. Leon, give us a little bit of the history of birthright citizenship.
Well, birthright citizenship is basically a product of the Civil War and the end of slavery amendments, the 13th, 14th, and 15th Amendments that were enacted to end slavery. And under the 14th Amendment, what it said was that anyone born in the United States that was within the jurisdiction of the United States, and that's going to be the key point, is a citizen. And so this had nothing to do with anything related to immigration. It was just to say you couldn't have people born here who were not citizens, because that was sort of the way of the world at that time, which is you had slaves and you had people who were not slaves. And to end that, you had to say people who were born here had the full rights of citizenship. And so that was the way it was written to end slavery. Now, what that translates to for the purposes of post the enactment of the 14th Amendment and where we are today is that any person born in the United States is a citizen. So that can literally mean that if someone was here on a tourist visa and they had to go to the hospital and then the baby was delivered at that moment, that baby would be a U.S. citizen even if they only spent one day in the United States. As long as they can get the recording of the birth in the United States, that baby would be entitled to U.S. citizenship, which also means that when that baby turns 21 years old, they could actually petition for a green card for the parents who were here on a tourist visa as well.
So that language of the 14th Amendment, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. And some proponents of immigration restrictions have argued that those words, subject to the jurisdiction thereof in the 14th Amendment, allow the U.S. to deny citizenship to babies born to those in the country illegally.
So the real purpose of that language of subject to the jurisdiction is to cover the following situation. If I am here and I am working for the Embassy of Denmark, let's say, that means that I am, an ambassador or a consul general or something. I am subject to the privileges and immunities of something called the Vienna Convention on Consular Relations. You may have seen, or your viewers or listeners may have seen, movies like Lethal Weapon, where people say, I have diplomatic immunity. You cannot arrest me for whatever crimes I'm committing in this movie or whatever. And that comes from the Vienna Convention on Consular Relations, meaning people who have diplomatic immunity are not subject to the jurisdiction of the United States. So what does that mean? If people who have diplomatic immunity have children in the United States, those children do not become U.S. citizens. That's what that means. It's historically been meant to apply to people with diplomatic immunity. President Trump and staff, they want to say that someone who is here in America illegally, who has children in the United States, is not covered by the 14th Amendment, because they're saying that they want to interpret this clause of not being subject to the jurisdiction of the United States as meaning that those individuals don't get birthright citizenship, which has not been historically the case. Historically, even if an undocumented person has children, those children are American. Here's what's interesting about that. If you really want to make that argument, what you would technically be saying is that an undocumented person is not subject to the jurisdiction of the United States, meaning that they have diplomatic immunity. So someone who's here without status could actually, park their car illegally or speed or do something else. And they would say, well, you know, the president says that I'm not subject to the jurisdiction of the United States. So there you go. End of story. So I don't know how they intend to harmonize that point for the purposes of this discussion.
Is there only one case, one Supreme Court case that's considered
Correct.
this?
There is a case from more than 100 years ago called United States versus Wong Kim Ark. And it was a case where there was a child born in the United States to Chinese parents who at that time were prohibited from becoming U.S. citizens because there was all of these laws about how to exclude Chinese nationals, and then there was laws about actually deporting legal Chinese people who were here. And so they were trying to deport this child who was part of this, you know, just Chinese desire to deport people from China. And they said that in this situation, that child is a U.S. citizen. You can't actually deport this person because the child was born in the United States. And so that's the only case we have analyzing that issue. And the question is, okay, if President Trump issues an executive order, when it gets challenged, would this version of the Supreme Court decide, no, we're going to actually look at this again and decide that this subject to the jurisdiction actually can be interpreted in a way to prevent people who are undocumented from being able to have kids who are U.S. citizens.
So, as you mentioned, Trump said that he could enact a plan to do away with birthright citizenship through an executive order.
Correct. And the plan would be as follows. What he would try to do is to force the issue and get it before the courts in this way. He would just issue an executive order that says, Dear United States Passport Office, if somebody comes and applies for a passport and the only thing that they hand you is a birth certificate and they don't give you anything else, you're going to have to find out some information about the parents before you give them a U.S. passport. And this will require a major change in the way the passport office operates. Currently, you show your birth certificate, that's the end of story. They confirm it with the state registrar, and that's the end. You get a passport. Now you will have to show some information on at least one of your parents to show that at least one of them was legally here inside the United States at the time of your birth. And so that's going to be quite fascinating because that will require a whole new adjudication to occur that didn't previously occur. So on top of just the normal adjudication that would be, well, is this whole exercise of trying to get rid of birthright citizenship illegal? And that litigation is certainly going to happen. There might actually be case-by-case adjudication, which is permitted. There's a lot of this passport adjudication that goes on in America, which is that when the State Department denies you a passport, you can actually file a federal court case. And you can say, look, I don't have this information because my mother or my father abandoned me or whatever reason. And you might be someone whose lineage is here 400 years, but you don't know because you were abandoned by your parents or something else. And it's all going to be quite fascinating to see how the passport office handles all of this. But that's the idea. Get that case in motion by triggering through an executive order an instruction to the State Department that says, don't just accept the birth certificate. You're going to have to find out some information about the parents of these individuals to see if at least one of them was in legal status before this child was born, before you give them a U.S. passport. And then there's a belief that the executive order would also cover the Social Security Administration and would say that if a child tries to apply for a Social Security number, that Social Security number wouldn't be given unless, again, there's some belief that the parents were in the United States legally. This also would require a dramatic change in how the Social Security Administration does this, because a lot of this has already been sort of automated through the hospitals. And you have a hospital and you have a birth and you have a birth certificate and then you have a Social Security number that gets generated. And a lot of this is quite almost automated in its nature. And so now you have to add this new and quite potentially burdensome extra requirement that you provide all of the evidence on the parents. It's going to actually be quite a cumbersome process while it's in litigation.
If he issued an executive order like that, it would immediately be challenged in the courts.
Correct.
What do you think the chances are that the courts would allow that?
My sort of belief in terms of if you had judges that were chat GPT judges and not human judges, for instance, I don't think the case would get very far, meaning I don't think that you could end birthright citizenship in this way, because I think given the historical interpretation of it and given what this word subject to the jurisdiction means and what it was intended for, I don't see how it would be possible to say that it was intended to cover undocumented individuals. So I do think it would be more of just saying you tried and then having the court shut it down and then moving to some other mechanism to try to resolve this. But because the judges are human and there isn't just a chat GPT component to this, you never know. Maybe some people will make that argument, because there's certainly a lot of political people making the argument right now. But I just don't think you get to 5 Supreme Court justices at the end of the day on this issue, because I think the textualists will be clear that we know what the intent of this was at the time it was written, and there's no way we can say it meant to cover this issue of immigration, because during the Civil War, we still didn't really have immigration laws yet in the United States. The first real immigration laws came after the Civil War in the late 1800s. So the idea that anything related to the 14th Amendment had anything to do with immigration would be very difficult to justify, because it just wasn't in the cards at that time.
Okay, stay with me, Leon. Coming up next on the Bloomberg Law Show, why MAGA is fighting over H-1B visas. I'm June Grasso, and you're listening to Bloomberg. Donald Trump has promised a crackdown on illegal immigration on day one of his administration. He's also promised to get rid of birthright citizenship, which gives anyone born in this country American citizenship, even if their parents are here illegally or are here legally on tourist visas.
My order will also end their unfair practice known as birth tourism, where hundreds of thousands of people from all over the planet squat in hotels for their last few weeks of pregnancy to illegitimately and illegally obtain U.S. citizenship for the child, often to later exploit chain migration to jump the line and get green cards for themselves and their family members.
I've been talking to immigration law expert Leon Fresco. Leon, Trump could attempt to end birthright citizenship through a constitutional amendment. Theoretically,
Yes.
because a constitutional amendment requires 2/3 of both houses and
Correct.
ratification by 3/4 of the state legislature. So it's almost an impossibility these days. Are there any estimates of how many people have birthright citizenship who are born here, but their parents are not here legally?
Well, one of the issues is it's going to depend how you want to define the excluded class, because some people want to say your parents had to have had citizenship or at least a green card, meaning lawful permanent residence. And if they were here on any other visa, meaning a tourist visa, so even if they were here legally, but they were here on a tourist visa or a work visa, and some of these work visas can be quite extensive in terms of their length, that these still wouldn't count to confer birthright citizenship. So if we were talking about that, we'd be talking about millions of people. If we're talking about just the children of two purely undocumented parents, we're probably talking about hundreds of thousands of people. So we're not talking about millions of people, but we are talking about hundreds of thousands of people. But there is some concern, and it has been raised in the past, and it's certainly not something that is non-existent, about this concept of quote-unquote birth tourism, where people come to the United States for the purpose of creating a United States citizen child that can then be used to apply for the green card for the parents 21 years later. And that certainly does happen, and I've seen those cases, so it's not that it doesn't happen. But the question is, would those people also be excluded from the group? I know that they want to exclude those people moving forward, but then actually you also have some legitimate questions about, there are many scenarios where what is happening is it's not quote-unquote birth tourism, but that a country doesn't necessarily have a specific medical advanced thing for whatever medical situation is happening in a pregnancy. And the doctors in that country will say, hey, you really need to travel to the U.S. because you have a very high-risk pregnancy, or there's some complication with the fetus, or whatever it may be. And the question is, are all of those people going to be banned from entering the United States? Currently, those people aren't banned. What they have to show is that they have enough money to have the coverage and cover the cost, and that there really is some medical urgency for this. And if you don't actually have any immigration problems in your background, you can get a visitor visa. And would this be eliminated here, even in these cases of very high-risk pregnancies? I don't know, but it would certainly be one step backward in these specific humanitarian cases.
And let's say there is birthright citizenship. A child is born 21 years later, tries to get green cards for his or her parents. Are those green cards easy to get if you're a citizen?
Yeah, believe it or not, they are. The test would be that you would have to show that there's a U.S. citizen, which that child is now, who's over 21, and that they are applying for their parents, and that there is an actual parent-child relationship there. And that's it. That's the test. I mean, the only other thing that is required is you need the child to have a certain amount of financial means in order to guarantee that the parents will not be dependent on welfare. But usually what happens in that situation is the parents will gift the child the assets that are necessary in order to have that burden met, or they find a United States citizen who's willing to provide that guarantee that they won't use public benefits. But that's the only real obstacle, is this: who's going to be able to say that you won't be using public benefits? There's an asset test that's there that you can just say, I have sufficient assets to make sure that this doesn't happen.
Well, could Trump change that part of it and say, we're not going to give green cards that easily?
Well, what Trump could do is make it harder in that situation to meet the assets test. That certainly he can do through the public charge component of this, but he can't actually change how the green card works without changing the statute. So there you would need Congress, and you certainly could do that. You couldn't do it through the child, because then you'd have what's called two different classes of citizens, and you could have an equal protection problem. But you could do it through legislating against the parents, and you could say that a parent who gave birth to a child in the United States while either on a visitor visa or in illegal status is not able to obtain lawful permanent residence on the basis of that child. So you do it that way. You'd put a ban on the parent and not on the child. And so that way it wouldn't be an equal protection violation. And so you could do that, but again, this would require an act of Congress. And the question is, what is Congress willing to do on a bipartisan basis? I do think you could get to something like that if you had a larger overhaul of everything. And so you had some things that helped people who were already here, and then you did some things on the enforcement side and all of that. You could get to a bill like that. But just a bill that just did that would probably be unlikely to get any Democratic support without something in it that Democrats also want.
Let's talk about the H-1B visas and this public fight among high-profile supporters of Trump over these visas for highly skilled workers. Are we just talking about 85,000 visas a year? Is that the cap?
Well, here's what's very interesting about that. The program is actually quite complex in this sense. So there's first a 65,000 annual cap for people who apply for the visa, who have a college degree, and have a job that requires that specific college degree. Then there's an extra 20,000 for people who have a master's degree and have a job that requires that master's degree. So that's the key test, is that it has to match that. But in addition, there's an exemption from the cap, meaning you can exceed the cap in an unlimited amount for any individual who is employed by either a nonprofit research institution. That would be things like, the Scripps Research Foundation or the Brookings Institute or any nonprofit that does research, or a university. So a university can also employ the person, and also the government themselves or a contractor who's providing the services to the government. And so through those mechanisms, you actually have, maybe 300,000 people a year who use the H-1B visa one way or the other in order to remain in the United States. And the traditional pipeline is you come as a foreign student, you then do something called OPT, which is optional practical training, which is something that was invented by regulation, which allows you to work while you are on a student visa. Then, if the company that you're working for likes you, they petition for you to have one of these H-1B visas. And then, if that happens and they like you even further, they can petition for you to have a green card. But the problem is these green card categories are all backlogged for many, many, many years. And so what's happening is people are stuck on these H-1B visas for many years, and both the people on the H-1B visa, but also the competitors for the people on the H-1B visas believe that this creates a workplace situation that is very anti-American worker, because if you have people that are basically stuck at an employer, then that not only makes them in a difficult situation, but it also makes the American competitors disadvantaged, because why wouldn't an employer prefer someone who's stuck than someone who has free agency?
So, Leon, it doesn't seem like it's that many people then. Why this focus on it? I mean, we're not talking millions, are we?
Correct. We're not talking millions. The reason I think that you see this anger in this debate is because it's a very emotional debate, meaning that the people who feel that they've been aggrieved by this feel that they've done everything correctly, meaning they've gone to a university, they've obtained a degree, it's been a degree in some subject that's not been a highly desirable one, meaning you're doing something very difficult in school. You're getting an engineering degree, or you're getting a mechanical engineering degree, or something that is a very, very difficult, arduous experience. So you do all of that, and then at the end of the day, your reward isn't like it might be if you go into banking and you're making millions of dollars. You're making not so much money, and you're competing with people from all over the world where those people are driving down the cost of your wages. This is what people get angry about. And even if it hasn't happened to them, they anecdotally will know of a story in which it's happened, and they get upset about it.
And so what are Trump supporters who are critics of the H-1B visa program looking to do?
Basically, here is what they would want to do, and this is where it gets super complicated. Right now, unlike the green card process, because when you apply for someone for an employment-based green card, in many circumstances, not all, but in many, the way you have to get that employment-based green card is to do what's called a labor market test, where you prove to the Department of Labor, I tried to hire an American, but that American was not available. And so that's why I had to hire the foreign national. Now, there's a lot of criticism about how that process works and how people operate in it and all of that. So that process is by no means perfect, but they want to put that into the H-1B as well, because right now the H-1B does not prevent a company from directly hiring a foreign worker without trying to first determine if an American was available for the job. There are some people who just want to end the program, or to have President Trump do a travel ban like he did with other visas, when there was the Middle Eastern travel ban, and just say, look, I'm banning the whole program. But that's not ultimately what the press release of President Trump said or what others said. What they came to is this other debate of where they want to go is to say, if somebody's going to hire someone on an H-1B, they have to show that there isn't an American worker who can do that job. But here's where that gets complicated. The H-1B statute was written with such detail and complexity, unlike any other statute, because when it was written by staffers and legislators who knew how contentious immigration was and how it could be subject to the whims of different administrations. So they were very wise at the time in how they implemented their goals. And so unlike many other things, these individuals actually were very, very careful in how they wrote it. And so any change to the H-1B pretty much has to be done by statute, meaning Congress has the right to change it. It's very hard to change it administratively.
And big picture, Leon, do you think that come Inauguration Day, Homeland Security is going to be geared up enough to start deportations that we'll see that?
I think you will start to see operations that are meant to capture the public attention. So I think they will say, here, give me a list of people with criminal convictions and give me a list of people with deportation orders that have already been issued. And we're going to start operations in big cities that are for the purpose of finding those people and detaining them and putting them in deportation proceedings. And so the idea will be that by doing those operations and announcing them and putting them in the press and perhaps doing some things that were more noticeable than in the past. So maybe instead of going to the person's house, you go to the person's workplace or to some other public place and pick the person up. That would lead to sort of more tension and nervousness in the communities that are affected by these operations, so that people would start to say, well, I can't live with this kind of stress. I'm going to just leave the United States. And so I think that's what you're going to see. I don't think you're going to see millions of people being detained or any of that. I don't think there's the infrastructure for it. There's not the legal resources for this. But the idea is, can certain operations be created that have enough publicity and create enough nervousness that people will then decide that they want to leave the United States?
I have a feeling the next 4 years, there's going to be a lot of immigration issues for you to talk about, Leon. Thanks so much. That's Leon Fresco of Holland Knight. Coming up next, Justice Clarence Thomas appears to be off the hook for those ethical violations. This is Bloomberg. Justice Clarence Thomas has been mired in controversy since ProPublica revealed in 2023 that he accepted luxury trips and gifts worth millions of dollars from a GOP mega-donor for decades. And now the federal judiciary has decided Thomas will not face a federal investigation of ethics violations. The U.S. Judicial Conference announced that it will not refer allegations that Thomas may have violated ethics laws to the Justice Department. The conference also announced that it will not refer allegations that Justice Ketanji Brown Jackson failed to report her husband's income from medical malpractice consulting fees. Joining me is ethics law expert Stephen GIllers, a professor at NYU Law School. In this letter, Judge Robert Conrad, the director of the Administrative Office of the U.S. Courts, said the Judicial Conference does not superintend the justices of the Supreme Court, only lower courts. Is that really the case?
No, it's not. And that's the most troubling part of Conrad's letter, because that view means that no justice, not only Thomas in this instance, is subject to referral by the Federal Judicial Conference. I think that Conrad's conclusion is indefensible. Certainly it is not defended credibly, and that's surprising in and of itself. Remember how we got here. There's a prelude to this, and for a long time there was no code of ethics for the Supreme Court at all, and then it adopted one in 23 without an enforcement provision. And various observers thought, well, maybe the Judicial Conference would be the enforcer. Maybe there's some way to create authority or jurisdiction in the conference to enforce the new Supreme Court Ethics Code. But that never came to pass. And so we have in that code a document that is really aspirational only, because a justice could violate it clearly and still not be subject to any kind of enforcement or sanction or repercussion. However, when we come to the financial disclosures, we're in a different category altogether, because Congress has said that the financial disclosure rules apply to all judicial officers, including the Supreme Court. So we have congressional authorization for other branches and agencies of government to view justices as within the financial disclosure obligations. And then Congress has also said in the Ethics in Government Act that when any of certain listed actors have reasonable cause to believe that a judicial officer has willfully violated the financial disclosure requirements, that person shall, it's mandatory, shall report the violation, or at least the reasonable cause to believe, to the Attorney General. And that includes the Judicial Conference, a duty to report to the Attorney General when there's reasonable cause to believe there's a willful violation. Now that brings us to Thomas and his many receipts of bounty from others during the course of his presence on the court. And in reviewing the allegations of Senator Whitehouse and Representative Johnson, Mr. Conrad, Judge Conrad, remarkably never says that Thomas's conduct, as reviewed by the conference across 2 years, does not reveal a reasonable cause to believe that he willfully violated the reporting obligations. It does not exonerate Thomas from that charge. I mean, that would have been hard enough, but it does not.
Yes, so Senator Sheldon Whitehouse said that the judiciary's response contains a number of inconsistencies and strange claims and doesn't address whether there's reasonable cause to believe that Thomas willfully broke the disclosure law.
Rather, what Conrad says is, well, he says three things. Well, it's all been taken care of now, and Thomas is in compliance, but he's not in compliance. Even apart from the trips and the personal hospitality, there are other things he did not report. And second, he says that, anyway, the reporting obligation to the Attorney General does not apply to justices, even though the two statutes we're talking about applies to justices. And for that proposition, he says, well, one of the sentences in the federal code about reporting refers to circuit judges and reporting to the judicial council of a circuit or district judges. And given that sentence, it must be that the Congress did not intend for reporting of Supreme Court willful violations, which is a non sequitur. If a lower court judge is guilty or may be guilty of willful violation, you report to the circuit council, says the statute. It doesn't say you don't report to the Attorney General. The Supreme Court justices are not subject to judicial counsel, so you can't report to the judicial council for a justice. But the sentence still remains that the conference shall report reasonable cause to believe willful violation. And finally, Conrad seems to think that the council just doesn't have power because it was not authorized, specifically authorized in the statutes to report such findings of reasonable cause to believe there was a willful violation. Now, this is a remarkable statement. The idea that a federal agency needs the approval of Congress to report that a federal official may have willfully violated a regulation is incomprehensible. You don't need congressional authorization. One would hope that any federal worker who has reason to believe that another federal worker is willfully violating a federal statute, that they could report without going first to Congress and asking for specific authority to report. So the idea that Conrad feels that he is without power to report wrongdoing or possible wrongdoing because Congress didn't tell him to is quite sad and troubling. It suggests that we may never get, even for statutes that specifically recognize justices as within their ambit, we may never get any kind of opportunity by an outside body to review their conduct with a view toward determining whether or not their behavior violated a law that Congress passed. This aggravates the situation, but it seems like there'll be no place to go after this unless Congress legislates, which is unlikely.
He also said that the request became moot when the Democrats asked the AG, Merrick Garland, to appoint a special counsel to investigate.
Right. And there's a problem there, too, because the conference has spent 2 years looking into Thomas and perhaps into Alito. Presumably, in those 2 years, they have gathered a lot of information that they hope explains one of their grounds for not reporting Thomas. But that information may be valuable to the Attorney General. The Attorney General may get a letter from White House and Johnson asking for an investigation or what have you, but White House and Johnson don't have the information that Conrad has. And Conrad's not sharing it because he says Congress didn't specifically authorize him to do that. And so while it is true that others can complain, they can't complain on the same factual record, the record that Conrad will have accumulated over 2 years that could help in a decision whether or not the Attorney General should invoke the authority to seek a civil remedy for willful violation of the law.
We're talking about decades of travel and gifts, et cetera. And he only has to report them. He's allowed to take them, but he just has to report them.
That's right. And, when people were talking about the enforcement of the new Supreme Court Ethics Code, behind that complaint was the hope that enforcement could lead to some kind of sanction, because if it cannot, what good is it? Even if the sanction is only a public document disagreeing with what the justice did or did not do. This is totally different. This is only reporting. No one's asking the Judicial Conference to visit a penalty on Thomas or others who willfully fail to report. The penalty in the statute is in the authorization of the Attorney General to bring a civil or even a criminal action for willful failure to report, not a finding. That is, Conrad doesn't have to make a finding that anyone violated the law. He just has to make a finding that he has reasonable cause to believe that there was a willful violation.
So the referral for Thomas came from 2 Democrats in Congress. There was also a referral for Justice Ketanji Brown Jackson from a conservative legal group for not reporting her husband's medical malpractice consultations.
Yeah, this is remarkable because this is one instance, and just compare that to Thomas, one instance in which a relatively new justice failed to report a spouse's compensation and then corrected it. There's no parallel between the recidivist behavior of Thomas. We still don't know if the reporting that Thomas has done is complete. I think we know that it is not complete as regards certain things other than personal hospitality. So comparing Jackson to Thomas makes no sense. It's just a tactic to say, well, your side does the same thing, which is ridiculous.
Let me ask you about the Chief Justice's year-end report and his calling criticism of judges and justices and protests outside justices' houses intimidation of the judiciary.
Well, certainly going to a justice's house is troubling. The family is there, children are there. I think the federal judiciary has an interest in publicly criticizing picketing or demonstrations before a justice's house, but certainly not in harsh criticism of a justice's behavior. That's what it's all about. That comes with the territory. And critics of a particular justice for his or her opinion who aggressively in print, for example, criticize that justice, that's what the petition clause of the First Amendment is all about.
The Supreme Court, as you know, the latest Gallup poll is at an all-time low. And I keep on saying every time there's a new poll, all-time low, because it keeps getting lower and lower.
Yeah.
I mean, none of this will help people to have more confidence in the court.
No, but let me be an optimist for a second.
Okay.
Against my better judgment. The Supreme Court first sat in 1790. Justice Thomas came on the court in the 1990s, 200-plus years later. Between 1790 and 1990, we did not have a serious problem. Fortis is the most obvious one in the last 75 years. And that was comparatively minor, Justice Fortis's behavior. Justice Douglas created a lot of waves, but also comparatively minor compared to what we have today. What we have today is 90% a result of the behavior of one man, Clarence Thomas, and to a much lesser extent, Justice Alito. Both are in their 70s. Even if we do nothing, time will change the composition of the court, and they will no longer be on it. And so my optimistic wish is that once they're gone, and especially once Thomas is gone, we'll revert to the relatively quiescent era between 1790 and 1990, that Thomas is a one-man reputation destroyer for the court. He seems to have no sense of responsibility and no sense of shame. But most of the problem the court is facing now is a product of his behavior, if we're talking about behavior of justices. Other reasons the court is suffering is because of its decisions, most particularly the Dobbs decision, but not only. There's no way to change that. That's inherent in the process. During the Warren era, the court suffered a reputational hit from the right because of the decisions, Miranda and others, that the Warren court adopted. That's their job. I mean, we may disagree with what Gorsuch or Kavanaugh believe, but they're doing their job. There's no reason to believe their conclusions in those cases are improper, that is, they're influenced improperly. They're saying what they think. We may not like what they think, but that's what they're doing, and it's what we want them to honestly do, although some might prefer that they reach a different result.
Always a pleasure. Thanks so much. That's Professor Stephen GIllers of NYU Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.